if you become aware of some misunderstanding, they don't know that you're a lawyer, well, there's a duty to correct that. So you have to be aware there. You can't give legal advice. So you have to watch out. And yeah, in the electronic age, maybe that rule 4.
I can see all kinds of things, especially in like family law matters where you may just be whether it's a case or not. You go up there and the husband or wife is putting all their dalliance or whatever they can put. They're just volunteering this information to your investigator who has a certain handle that they're using online. And, I've seen those things happen in cases. Just curious.
Yeah, well, if they're not represented at that point, they're not. Then it's Rule 4.2. So I guess that would, before engagement, a close look at them. You are allowed to communicate with them, but there are just a few obligations to correct misunderstandings. That you will see amendments in many years. Finally, Rule 4.4, respect for the rights of third parties. You have to, basically, with respect to third parties, it's a pretty minimal obligation. You just have, you can't do things merely to inherit, delay, or burden them. You can do it, you can burden all the third parties in the world, but you have to have some legitimate purpose. You can't do it just for the purpose of embarrassment. And will not use methods of obtaining evidence that violate a third person's rights. So if I sift through the papers in the apartment dumpster, that apartment dumpster is owned by third parties. They're violating their right to sift through it. I don't know. Not necessarily the issue to solve there. And the question of inadvertently sent fax or email is covered in the rules. Basically, if you get a fax or email by mistake, you have to stop reading as soon as you know what's going on, and have to tell the sender that you got it by mistake. Rule 4.5, I don't know why I didn't delete this, because it's Wisconsin has a guardian ad litem division in the rules. I'm sure that's covered in your state statute somewhere else. But since it's here, that will be, and especially if you're taking for Wisconsin credit, be sure to read 4.5. And our fourth code word is litem, L-I-T-E-M, short for guardian ad litem. That's our fourth code word. So we are kind of in the final stretch here. We talked about most of the rules. Now, 5.1, we're talking about so we've learned all the things that you do to get yourself smart. What can other people do to get you to smart? To what extent are you responsible for the conduct of third parties, like people working under you, people working above? If you're a manager or supervisor of another attorney, first of all, you have to make sure there are measures in place to make sure that the others are following the rules. You can't bury your head in the sand because that new associate down the hall is, has dubious methods. So if you're saying that you have that duty, and you are responsible for their violation if you order them to do it. So obviously, you tell your associate, go commit, breach of conduct. If you ordered them to do it, obviously, or if you didn't do that, if you learned of their misconduct and you could have cleaned up the mess before it got too bad, well then you should have fixed the problem. That talks about your duties as the boss. Rule 5.2 talks about your duties as the underling, as the person who's being supervised. And Rule 5.2 says basically that I was only following orders does not constitute a defense. So just because your boss told you to violate the rules, you're not responsible for that violation. But there is actually an exception. When I was only following orders, he is a defense. That's if you act in accordance with the supervisory lawyer's reasonable resolution of an arguable question. That's you're not a prosecutor in Iowa, and your client is going to steal $1,000. Well, is that a substantial amount or is it insubstantial? So you ask your boss, and your boss says, "Oh, it's substantial." friend. It turns out your boss was wrong. Well, your boss can get in trouble then, because the boss told you, gave you that advice, told you to do that. But even though it's a violation, you're in the clear here, because you acted in accordance with that reasonable resolution. Turns out it was wrong, but it was reasonable. So the one time I was only following orders. Rule 5.3 kind of says the same thing as 5.1, except it has to be worded differently. 5.1 says situations you're responsible for lawyers under you doing things. Well, Rule 5.3 talks about when you are responsible for your non-lawyer assistants. The rule is the same. It's just worded differently, though, because Rule 5.1, the lawyer needs you. Well, if he does something, he can get disbarred. So he's violating the rule. Well, your secretary can't get disbarred, or the messenger can't get disbarred, because they're not attorneys. But pretty much the same rules apply. You have to have systems in place to keep problems from happening. And obviously you can't order them to violate the rules. Or they do, if you see that they're violating your rules, then you have to mitigate the problem. Rule 5.4 is kind of a lofty title, professional independent lawyer. And then it talks about fees, talks about money. Well, because money makes you not other than independent. And so the title for Rule 5.4 should be sharing fees with a non-lawyer. Don't do it. You can't share your fees with a non-lawyer. Except in certain cases you can share, your law partner passed away and you owe money from this fee. Well, obviously they said even though the estate is no longer a lawyer. You buy the practice of a deceased or disabled lawyer, they're not a lawyer, but you share the money with them. Or a disappeared lawyer. If the lawyer disappears and you buy it from them, you can share it with the disappeared lawyer. Which begs the question, where do you send the check? I guess it reappears if you pay them for practice you buy it. You can have a pension plan or profit sharing plan for your non-employees that pay outside this of this, so make sure you check those rules very carefully. And if the court awards fees, court award attorneys fees, you can share with your client in certain non-profit organizations. So even, it's kind of a technical exception, even though technically sharing it with your non-attorney employer is okay. You can't operate as a partnership with a non-lawyer if one of the things you're doing is practicing law. And like we talked about earlier, you can't have your services directed or regulated simply because somebody pays you. Your client is in charge, not for paying you. And if you're set up as a professional or professional association, make sure you look at the rules because obviously you're a corporation, not a lawyer. Rule 5.5 talks about the unauthorized practice of law. Well, really, the one thing in the world they're not engaged in, the unauthorized practice of law, is your lawyer. But what comes up is in two situations. One is if you assist somebody else in engaging in the unauthorized practice of law, but the jurisdiction thing. So I am admitted in Minnesota. I am not admitted in Iowa. What am I allowed to do here on Iowa soil without engaging in the unauthorized practice of law? Well, I can do quite a bit, actually. As long as I'm not disbarred or suspended, well, that's easy enough. I mean, you're disbarred or suspended. You don't have to raise your hand if you want. Watch out for that, though. Just disbarred or suspended for any reason in any jurisdiction. Okay, so you're an Iowa attorney. You live in Iowa. Your entire practice is in Iowa. You don't plan on going anywhere else. You're also admitted in Oklahoma. You have no interest in ever practicing law in Oklahoma. You don't want to go to Oklahoma. You don't want to do that. So you just decide, why am I spending $500 a year or whatever to maintain an Oklahoma license? So one year you decide, I'm just not going to pay this anymore. So, well, that's fine. That doesn't affect your practice here because you're still licensed in Iowa. You don't care about being able to practice in Oklahoma. You're not planning on going there anywhere. But if you ever come to Minnesota to take that position, then you look at this rule, can't do it because you were suspended in any jurisdiction. So if you do have, if you are licensed in some other state and you want to let it lapse, make sure you jump through the right hoops to get put on inactive status or whatever in that state, because you probably don't. It could come back to haunt you if you're suspended in that state. But as long as that doesn't apply to you, you can do quite a bit in other states. Now, interestingly, if you are suspended in Oklahoma and you decide to go to Wisconsin to take that deposition, they wisely have an exception in there that the suspension has to be for disciplinary reasons, not just a mere non-payment thing. But if you take the deposition in Minnesota or Nebraska, you can't do it because of that provision. But here's what you are allowed to do. You work in association with another lawyer who's submitted an A. So I can serve as co-counsel for any of you, whatever. Something that's related to a potential or proceeding, I reasonably expect to be authorized to appear. So if I walk out here today and I witness some federal case take place, I'm not positive, but I can get admitted in the Iowa federal court pretty easily. I can probably get admitted in the Iowa state court pretty easily. I can reasonably expect that I will be admitted, maybe with local counsel. So I can start getting ready for that case, and even though I'm not admitted yet. So I can interview the witnesses, do a lot of things. So that was pretty broad. And if all the arbitration kind of thing will apply. If it arises out of my practice in the state where I am admitted. So I have a case in Minnesota, and we have a deposition, and the deposition witness happens to be in Iowa, so we're going to do the deposition in Iowa. Yes, I can come down and take the deposition. Or if it's kind of federal law. So I work with radio station clients at SPD, and I'm admitted in Virginia, but I can fly here to talk to my radio station client in Iowa. Yeah.
I'm licensed in Iowa. Somebody in Oldham calls me up in Florida, and they want legal advice. I said, look, I'm not an attorney in Florida, so I can give you an opinion on that situation. Did I just violate? Am I practicing unauthorized practice law in the state of Florida, although it's over the phone when I'm saying?
Well, yeah, that's a good question. Now, first of all, I don't know what the Florida rule is, so I don't know if Florida has the same rule or not.
Right. So
that's really what you have to look at. But assuming that they have the same law, maybe. Definite maybe.
A definite maybe that I'm
well, you have to fit into one of those things. Yeah, if you,
it's not a trial, there's no proceeding.
Well, could there possibly be some proceeding at some point?
Yeah, absolutely.
Do you think you could get it in the Florida federal court? I think you could.
Yeah.
Because most of them. So I would put it under that. I got
because that happens all the time.
I know. I got a cousin in Indiana called, and this attorney is just. She thought it was a foreclosure. She thought it was taken care of years ago, and then this lawyer comes out of the woodwork trying to correct a deficiency judgment that she thought was set aside years ago, and he